let's talk about legal research for judicial writers. First, a couple words about why good legal research is incredibly important for judicial writers. First, there is no one to point out you're wrong except the court above you. And getting reversed is not only disheartening for the judge, but often a hardship to the parties who relied on the judge's decision. Judges are usually generalists. They're not necessarily experts in all given areas of law. Thus, they cannot rely on years of practice in one specific area to hone their legal intuition in each case. They must check themselves constantly, especially when addressing legal rules that are new to them, which is often the case. A judge's reputation is based largely on getting the law right. And a judge's reputation is not only personally important to them, which it is, but also important to the public's faith in our legal system. Judicial writing is where the law is developed. It's where it's improved. Without good legal research, flaws in legal reasoning or rules can persist for years or even decades. Legal research for judicial writing is similar to legal writing in general for many respects, but there's some key differences. The most obvious difference is that in judicial writing, the legal research has already been started by the parties. At the least, the parties frame the issues to be researched when they decide what claims and defenses to raise. Thus, a judicial writer does not generally get to pick what issues to research, unlike an attorney, who will often spend extensive time conducting legal research to figure out which claims and defenses and rules even apply. What makes judicial legal research tough is that the parties often do horrible research, or worse, misrepresent the cases and statutes they do find. So judicial writers need not only do really substantive, great legal research, they often must tangle with deciphering the parties' confusing, sometimes even misleading representations about what the law says. In addition, judicial writers sometimes do need to go beyond the legal issues raised by the parties. For example, some issues like jurisdiction can and should be raised by judges on their own, regardless of whether the parties raise them. Also, judges will sometimes have to settle new questions of law never addressed in that court before. Thus, the judicial writer will need to do extensive research, far beyond what the parties will usually do. Let's now talk a little bit about the general research process. Judicial legal research is about figuring out what legal questions need to be answered and then how to answer these questions. Before starting any research, it's extremely important to first figure out what legal questions need to be answered. Mapping out these legal questions will guide the entire research and drafting process. To figure out the legal issues that need to be settled, judicial writers first figure out the procedural standard that governs the party's motion or brief, and then the standards or requirements that the parties must show to win on their claim or defenses. This process is very important because often the parties will raise totally relevant issues, arguments, or rhetoric, so you have to know which standards to apply on your own. Next, you figure out what issues the parties actually dispute. You will then, after applying these 3 steps, be left with the questions you actually need to research and then answer. For example, if a party moves for summary judgment to win on her employment racial discrimination claim, you would ask, what is a legal standard for summary judgment? And then, what standards or requirements govern a discrimination claim like this? The summary judgment standard requires a moving party to show a lack of genuine dispute of material facts. The requirements of an employment racial discrimination claim are showing that a supervisor took an adverse action because of the plaintiff's race. Then you look and see what do the parties actually disagree about in their motion and response. So let's say the parties agree that a worker took an adverse action against plaintiff because of her race, but they disagree about whether that worker was a supervisor for purposes of the discrimination law. Now you know the legal question you actually have to research. Has the plaintiff shown there is no genuine dispute of fact about whether this worker was a supervisor? Now let's talk about how to answer these legal questions once you figure them out. One thing to keep in mind during the research process is that a judicial writer usually cares only about binding authority. Because if a binding authority has answered a legal question, the judicial writer must apply that answer. Only if binding authority has not answered a question may a judge explore and make a new decision. So, for example, if the United States Supreme Court has said that 2 comments about race can never be enough to win on a discrimination claim, the federal trial court would have to apply this rule, whether it agreed with it or not. Let's now talk a little bit about the research steps judicial writers will generally take. First, if the judicial writer is not familiar with the general area of law, he or she will often consult treatises. Parties often cannot be trusted to explain the background law enough, and this context can be very helpful when generating search terms and getting an understanding of the legal questions. Next, judicial writer will need to generate search terms, begin researching. Good thing is, there's generally no restrictions on how much research you can do in most court systems. Good rule of thumb is to use cases the parties cite to figure out good search terms and sort of start your research trail and then go from there. The goal is always to locate primary binding authority. You should always start out with a statute, regulations, or the common law doctrines, and then move on to Supreme Court cases, appeals court cases, and then and only then, if you're in the trial court, to persuasive authority, which would be other district or trial courts, secondary sources, etc. It can also be helpful to save your research trails on Westlaw or Lexis to return to later if needed. You should use your research to create an outline of the law. Make sure to use an outline format so that you can keep your research findings on each issue separate for easy incorporation once you start drafting. Make sure to keep citations to any cases you think might be useful. The good news about legal research is that judicial writers have incredible legal resources to help them. First, they have amazing clerks answer a multitude of questions. Great to bounce ideas off of. Law librarians are also highly trained. All kinds of research techniques and sources. Finally, secondary sources can be very helpful to figure out how legal standards or claims actually work. And most courts have incredible secondary source resources. Hopefully this should have given you a basic overview of legal research process for judicial writers.